Clerk, raise your right hand.
Sir, do you solemnly swear the testimony you should give this court and the issue now pending between the Commonwealth and the defendant at the bar shall be the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely.
Thanks, sir. Can I call the officer?
Mr. Lee.
Thank you. If you wouldn't mind, could you just introduce yourself to the court reporter, and if you could please spell your first and your last name.
My name is Michael Gifford, M-I-C-H-A-E-L-G-I-F-F-O-R-D.
And Mr. Gifford, can you tell us what kind of work you do, sir?
I work for American Sweeping.
How long have you been with American Sweeping Company?
Around 10 years.
And what's your current title, and what are your current responsibilities?
Supervisor.
And what are your responsibilities as a supervisor?
Supervise the 5 machines that sweep the city of Boston at night.
All right. So American Sweeping Company has 5 street sweepers?
Yes.
All right. I want to direct your attention to July 16th, the early morning hours of July 16th, 2012. Were you a supervisor in 2012?
Correct.
And are you familiar, or did you know an individual by the name of Warren McMaster?
Yes, I do.
And how do you know Mr. McMaster?
Warren works for American Sweepers.
All right. And he was working for American Sweepers in July of 2012?
Yes.
All right. Now, in July of 2012, what shift were you working, or what were your normal hours?
That would be 10 to 6 at night.
10 p.m. to 6 a.m.?
Yes.
All right. And do you remember that evening for a variety of reasons?
I do and I don't.
Okay. Do you remember at some point in the early morning hours of the 16th receiving a phone call?
I do.
All right. And to your best memory, who was the person that called you?
Mr. McMasters.
And can you tell us in sum and substance what Mr. McMasters said to you when he called you?
He said I needed to get over at the spot on Marginal Street. There's something, Boston police over there, something. I have to get over there quick, so I went over there.
All right. And was that the first time you learned that Mr. McMaster was over in that area?
Correct.
And how did you get there?
By my vehicle.
Where, if you remember, where did you park your car?
Beyond Marginal Street at Washington Street.
Beyond Marginal at Washington. And from where you were parked, could you see either Mr. McMaster himself or the street sweeper?
I could see the street sweeper. I couldn't see Warren because he was tied up being talked to by the police.
All right. At some point while you were there, did you ever see Mr. McMaster?
I did.
All right. How far were you from the street sweeper and where it was parked in terms of blocks or distance?
I would say it's got to be at least a good 200, 250 feet away.
All right. Did you have any difficulty seeing the street sweeper?
No.
When you did see Mr. McMaster, was it from that same distance where your vehicle was parked?
Yes.
During the entire time that you were there, did you ever go to where Mr. McMaster was?
No.
Did you speak to anyone, namely police officers, when you arrived at the area?
No, I waited there.
Okay.
I was at the-
So no one, as far as you were concerned, nobody knew that you were there? Did you communicate with anybody that you had arrived?
A police officer did come up to me and said his name or whatever, blah, blah, blah. But other than that, I can't remember.
Okay. Now, during the time that you were there, did you ever see anybody, namely police officers, engaged in any heated conversation with Mr. McMaster?
Not that I know of.
Or what appeared to be heated conversation?
No, not that I know of.
Okay. Did you hear any yelling or screaming by police officers towards Mr. McMaster?
Judge, this is my question. Sorry, he didn't know where Mr. McMaster was, so any question?
No, he didn't testify he didn't know where he was. He said he saw him speaking with the police. And he was, did you say 200 to 250 feet away?
Yes.
All right. And you were able to see Mr. McMaster?
From the distance, yes.
All right?
Sir, may I correct the record? This individual testified he was 200 feet away from the street sweeper, and that Mr. McMasters was off somewhere dealing with police. He did not testify that he saw him.
Well,
And
you have your memory, I have my memory, and the witness has now told us. Make it clear, if you would, Mr. Gifford, were you able to see, visually see Mr. McMaster?
I could see him
Or was
down
he
there.
out of your sight?
I can see him down there talking to the police. Other than that, that was it.
Mr. Lee?
And from what you could see of Mr. McMaster speaking to the police, did you see anything that, at least in your mind, appeared to be the police berating or yelling at Mr. McMaster?
I couldn't tell you. He was a distance away.
Was there any flailing of arms that you remember?
No.
Okay. So I believe your testimony was, and you never ended up making it down towards where he was. Is that correct?
I was told to stay back where I was, and that's where I stayed.
And at some point, did you leave that area? In other words, did you leave to go back to your job or whatever it was?
Yes.
All right. And your workplace or your office is where?
It's on Tinian Street
All right.
in Dorchester.
All right. Not on Frontage Road?
No, Frontage Road is, no.
Okay. So when you left the area, by the way, when you left the area, you left without ever having spoken to Mr. McMaster. Is that correct? At least at that time.
Yeah, that's correct.
All right. And you returned to your office.
No,
Where did you go?
I went to meet the other machines, see what's going on.
Okay. And where was that?
Various areas in the city of Boston.
Did you ever make your way to Frontage Road that morning?
That I can't remember if I did or I didn't.
Do you ever remember seeing Mr. McMaster either by himself or with officers going through the hopper of the street sweeper that he was operating?
I don't remember that. Like I said, I don't remember going back to Frontage Road. It's very, there's nothing there for me to remember that.
Okay. Now, are you familiar with Frontage Road?
I am.
What is located there?
Frontage Road is where the city of Boston parks their vehicles. That's where they work out of.
So the street sweepers for American Sweeper Company that's where they're kept?
Our dump trucks are kept at Frontage Road for when we dump at nighttime. We dump the dump truck there, and then we transport it back to the office.
It being the street sweeper?
Yes, the street sweeper would dump into the dump trucks at Frontage Road. After it's done, we go back to the office.
Understood. Now, you said you have some familiarity with Frontage Road?
I do.
Are you aware at Frontage Road of any hoses or hose attachment to spray down the equipment there?
There are two hydrants over there that they can, they can hook up and wash the machine down.
With what kind of a hose? A fire hose?
It'll be a garden hose with a 2.5 inch extension.
And that would have to be done with a fire hydrant?
Yeah, they hook up to the hydrant.
And have you ever seen that used? How are the trucks normally cleaned? Are the street sweepers normally cleaned?
That's how they're cleaned off.
Okay. Other than your conversation with Mr. McMaster, when he told you that when he told you to go to the area of Marginal Road, did you have any other conversations with him that night that you remember?
No.
Do you remember ever being told by Mr. McMaster that he had to return to Frontage Road to dump his hopper out?
That's very possible, yes.
Okay. When would that conversation have taken place?
I couldn't tell you. I couldn't remember that.
Okay. When you say it's possible, are you not sure whether that conversation took place?
Objection, Judge Leading.
I'll rephrase it.
Rephrase.
What did you mean when you said that it's possible that you had that conversation with him?
I had a conversation, someone asked me a question earlier, and I said it was possible that he could have went over there and dumped.
And when you say possible, what do you mean by that? What do you mean by it was possible?
For him to go over there and dump, he has to go over there and dump. That's the routine.
And what is your memory about whether you ever heard that information, that he was being told to go over there and dump?
I don't know if he was told or not. I can't speculate on that.
Okay.
Well, it's not speculating, sir. I think the real critical issue is, do you have any memory of that?
I don't.
One way or the other.
Yes.
It might have happened or it might not have happened. You just don't recall.
I don't remember that.
Okay. And if someone did not complete their rounds, their assigned route for the night, would that be noted anywhere?
They complete their routes every night. If Warren was tied up with the whatever happened, I would have another machine finish that route.
And would that be noted anywhere in the records of American sweeping?
No, I don't think so. No.
You wouldn't make a shift note.
No.
Okay. Mr. Lee, anything further?
Just one last question. Do you have a memory, Mr. Gifford, about whether you did on that night get somebody else to finish up Mr. McMaster's route?
If he was tied up that long, I want to say yes. Yes, I had someone else finish that route.
And is that because that's what you always do, or
That's
do you?
that's a proper procedure.
Okay. Is it because that's that's the procedure you use, or do you have a specific memory of doing that?
That's the procedure. That's the way it's done.
Okay. Thank you, sir.
You're welcome.
Mr. Baez.
No questions. Thank you, sir.
Yep.
Hold on, don't go anywhere. When Mr. McMaster called you and said, come over here to Marginal and Shawmut, or whatever he told you,
Yes.
did you know how he knew that he should be there? Had someone sent him there?
I don't remember that. All I know, that's his route he sweeps.
Yeah.
And I remember him calling me, telling me to get over there. The police are questioning him or something in that effect.
Okay. At American Sweeper,
Yes.
2, 3 o'clock in the morning, is there anyone manning the telephones?
No, not at that office. No, sir.
If the police had to get in touch with the company, how would they do that?
If the police had to get it, they should be calling the city of Boston, Public Works.
Yeah.
They're the ones that inspects our work. And the supervisor that's on American Sweeping, that's how they can get a hold of the supervisor.
And that's you.
Yes.
Do you recall whether you got a call from anyone at DPW?
No. I remember, I want to say Warren called me telling me I had to get over there.
Does DPW have an ability to communicate with the sweepers, with the trucks directly?
They could call the operator on their cell phones if they had to.
They have those phone numbers?
Some of them do. Some of the work performance on the Public Works do have the phone numbers of the cars.
For all drivers?
Some of them, yes.
Okay. All right. Anything further from either side as this witness? Mr. Baez, nothing else?
No, sir.
Thank you, sir. You may
Thank you.
sit down.
Right this way, sir.
Commonwealth?
Nothing further, Your Honor, on this issue.
No further witnesses? Mr. Baez?
Court's brief indulgence.
Is Officer Griffin here, Your Honor, or did he show up? Canine. Griffin. understanding is that Your Honor did instruct the state to have him present.
Well, if we could locate him. It's really not part of the three motions before me, but I did indicate that if he was around, let's get him in here. Any luck?
Well, he was spoken to, Your Honor. I believe he had an eye appointment. He wasn't available.
Okay.
But I believe we were looking for information. I have the information. His dog was never deployed.
Stayed in the car?
Stayed in the car.
Okay. All right, Mr. Baez, any witnesses?
No, sir.
All right, then that will close the evidence on the three motions that are before me. Do you want to be heard?
Yes, sir.
Yep, I'll hear you.
May I first address the...
Well, Mr. Sullivan, you haven't been here to hear any of the testimony. You're now going to argue it?
Well, I'm going to argue at least two of them, the abuse of discretion and the spoliation. I agree with respect to the Brady, Your Honor, that I was out, and that better comes from Mr. Baez. If we're going to start with the Brady, that seems appropriate, given the most of the testimony was the Brady issue. Then I can argue the subpoena issue and the spoliation, which are much more characteristically legal issues.
All right, who wants to be heard on the Brady issue?
Your Honor, as it relates to the Brady issue, my arguments would be put forth as one with the papers, but secondly, I think the defense is established even through the defense, through the state's witness. Mr. McMaster's informed law enforcement that evening of his findings of identifying a white SUV, seeing a woman's come out of, I guess, stick her head out of the sunroof, and then using some type of recording device to either record or possibly record what was being observed. We have a lot of inconsistent testimony as it relates from law enforcement as to, one, whether this street sweeper was ever there. As you recall, not only we would ask that the court take judicial notice to the testimony of the trial at this point, specifically that of Sergeant McHale, who has testified that he never spoke to the street sweeper, that he was just informed by another officer as to the fact that one was in existence, and then he then made a call for the street sweeper to come back. But yet today we hear from Officer Boudreau that he observed Sergeant McHale speaking with the street sweeper. In fact, that's the only officer that he identified as speaking to the street sweeper that evening. Simply not to say that there weren't other officers that testified or that, excuse me, that spoke with him, but that's the specific thing that he can recall. I think you have to question the credibility of a lot of these officers, one, through their trial testimony, and two, specifically at this hearing. If you read this transcript, you hear Detective McIsaac questioning Mr. McMasters and constantly reminding him that he was the one that spoke with him. And of course, he's not documenting it. And I think we stand by...
Are you suggesting that that's false?
I think the purpose of an interview is to get information, not to give it. And so, yes.
Well, no, you just said that McIsaac was repeatedly telling McMaster, I'm the one you spoke with. Are you suggesting that is not true?
Yes, sir. That's exactly what I'm suggesting.
Right.
This
Notwithstanding the fact that McIsaac wrote a report shortly after that indicating that he spoke with McMaster.
Correct.
Okay. All right.
No, I'm not saying that he...
I just want to understand
no.
what the claim is.
My claim is not that he didn't speak with him, but that Mr. McMasters didn't tell him what he observed. Okay?
So you're not claiming that McIsaac fabricated an interview with McMaster?
Correct.
Correct.
Okay?
What I'm suggesting is that Mr. Detective McIsaac did not document. First, if you look at his notes, he's got one sentence of where this car or this street sweeper went by. Now, the issue here is at the time of the incident, the biggest concern that law enforcement have is that this street sweeper may have gone through a crime scene that was already established. Once it's already established, a crime scene, and a street sweeper goes by, that doesn't look very good for law enforcement. So to sweep it under the rug, no pun intended, they then try to assume that, he was too far to the right, and therefore there's no way he would have been or had any relevance to this investigation. They see you can clearly see that this is a young man, that they decided that they were upset that he had gone through their crime scene. This is consistent with them being upset, whether it's McIsaac, whether it's uniform officers. They're not happy that because they didn't do their jobs properly by securing that crime scene, that a street sweeper went by, and it must be the street sweeper's fault, not any of their own. So therefore, they're immediately not content with him, and they start to then harass and intimidate him, and therefore the ridiculous assessment by Detective McIsaac that there's no way that evidence could be gathered from that side of the street is absurd on its face, because they've established two blocks of a perimeter for the crime scene. Not only that, if a car, they don't know whether it's an automatic or a revolver, shell casings would clearly fall on that side of the street. He can come up here and still fight me toe to toe by saying, well, no, it would have been too far away. That goes, one, against common sense. Two, why not just set the perimeter of a crime scene 5 feet away if that's as far as they think that the shell casings may follow. In addition to that, they're not certain if any shots were fired from the BMW, which may end up or could have ended up on that side of the street. So there's a various number of scenarios that would show that when that street sweeper went by, there was a strong possibility that evidence was destroyed and lost forever. Due to whose fault? Due to the fault of the street sweepers. So the easiest way to sweep them under the rug would be simply, he's way far on the side of the road, that's all he had to offer, goodbye, see you next year. Okay? And that's exactly what the storyline was, rather than to give him any credibility to possibly seeing, one, a possible car that matched a similar description of the car that they're looking for, and two, of a potential individual that may, someone who appeared to be a female that he could identify. The issue then goes back to why wasn't this information disclosed? This witness was adamant, both through his interview with Detective McIsaac and here in his testimony today, that he did inform law enforcement of this information, and that it was simply he kept being harassed and told to shut up, sit down, don't fucking tell anyone, or you're going to be arrested. So I think based on all of the information that's supplied to the court, this court can conclude that information was conveyed to law enforcement. It's at that time they have the duty to disclose that information, to make note of it, and to disclose it to defense. None of this was ever done. I think the court can see a clear pattern here of whenever there's information about this crime scene that they don't find convenient, there's a lot of finger pointing going on. And there's a lot of sweeping under the rug as it relates to what's being noticed and who knew what and and at what time. And this street sweeper is the prime example of that. First officer on the scene doesn't see a street sweeper, but yet like the fourth officer on the scene does. So, and this is not just on the street sweeper. This has come out through trial on various issues, like the sheets and so forth.
Let's stick to the sweeper.
All right. My point is, Judge, is that you cannot accept, you should not accept this testimony on its face as it relates to law enforcement. when there's clear examples of where officers who should have seen certain things are claiming they did not. They are already at fault and already on the defensive when a street sweeper goes through their crime scene. And I think it is, they clearly...
Well, how are they at fault?
Because they should have set up a perimeter.
Well, they
and not
weren't
let-
there.
I'm sorry?
They were not there.
The street sweeper showed up after one of the officers was able to identify one of the street sweepers. That's how we found out about the street sweeper.
No, you found out because it's in the police reports that were written at around the time.
Correct, which is...
But I don't think there's any testimony that while the police were on scene, that sweeper came across the bridge, through the light, took a left onto Herald, in the midst of all the police investigation. At that point in time, I don't see how it would fit. We have two cruisers blocking the road. We have an ambulance up in the front. It doesn't seem like there's room for a sweeper.
I'm not saying that...
It seems to me, from the evidence as it's been presented and in the reports, that that sweeper went by sometime before the police had arrived. That is the evidence as I would find it. And took its left on Herald, kept going. At some point it was reported that a sweeper had gone through, and that's when a call was made to dispatch to try and get the sweeper back. And then McMaster picks it up saying that he came back on the marginal street side of the bridge.
Let me rephrase.
So-
Let me rephrase my argument, just because I'm not sure if I made myself clear. There was an officer that observed the street sweeper exiting the area.
Saw
leaving the
a
area.
sweeper in the area.
No, turning onto Herald Street from Shamat Avenue. And that's how we came about this
All right.
information. Unfortunately, that witness was not called in the hearing, but that is my understanding of how this all
Which
came.
officer was that?
I believe that's Officer O'Donnell. His report is in the exhibit number 1.
Well, has he testified to that? We're talking about what's in the record before us. Has he testified?
No, sir.
Has any police witness yet testified that they saw the sweeper come off Shamet onto Herald?
No, sir.
Okay. All right.
And that is our argument, Judge, that law enforcement had a duty to disclose this information under Brady, simply was not disclosed. I think the court has to find, one, that the information was there, that it was disclosed.
Yeah. Well, let's break down what the information is, because if I understand it correctly, there is no dispute that it was known and was reported. That is, there's no Brady violation to the fact that McMaster's swept the street, that he was called to return, that he did return and was interviewed by McIsaac, and the extent of what McIsaac says he said was contained in a report, and that report was timely disclosed. So that was disclosed. It seems to me, Mr. Baez, that your motion is predicated upon the additional details that Mr. McMaster says he told the police at the time that he saw a white SUV, saw a woman out the sunroof with some item in her hand that could have been a recorder or camera of some sort, and that thereafter he returned to Frontage Road at the command, I take it, of the police, and emptied and searched the contents of the hopper. It seems to me that that information was not contained in McIsaac's report or any other police report, and that is the newly discovered or newly disclosed evidence that you view as exculpatory.
Correct. There's also,
Those are the two new, or
Yes.
those are the two details that were not part of any prior disclosure and not part of any prior report.
Yes, sir.
Correct?
Now, there is one piece of information that Your Honor's leaving out, and that is, we just heard Officer Boudreaux testify that he observed Sergeant McHale speaking with the street sweeper, that Sergeant McHale interviewed the street sweeper. Now, Sergeant McHale has filed a report that he called the street sweeper back, but when he testified in trial, he testified that he never spoke with the street sweeper. So this is consistent and backs up this testimony by Mr. McMasters, who said he spoke with multiple individuals, some uniformed and some not. Here you have a sergeant getting on the stand and denying he ever spoke with a street sweeper when clearly another officer observed him doing so. Okay. And the witness testifying, of course, that that being Mr. McMasters, saying that he spoke with multiple officers as well. So that, in addition, I think I would agree with the court's assessment of what the additional information is as it relates to Brady, but I would support the court's findings with that information.
Okay, thank you. Now, Mr. Sullivan, do you want to speak to the other two motions?
Yes, Your Honor. With respect to the abuse of discretion and the subpoena power, the subpoena power, as the court knows, is authorized both under the Massachusetts General Laws and Massachusetts Rules of Criminal Procedure 17A. It is axiomatic.
Do you have a phone? Yes,
It is
sir.
axiomatic, both under the statute and under the rule, that subpoenas cannot be used as a tool for general investigation. Moreover, it's improper, and there's a long line of cases that tell us that the government cannot essentially subpoena an individual to its office for investigative purposes. This subpoena, and I will focus, I think the cleanest example is a subpoena for Friday, March 3rd, 2017 at 9 a.m. This is one of the three subpoenas. I think each could be a separate violation. I'm going to focus on this one for expository ease and for illustrative purposes. But what has happened here, Your Honor, this does not come out of a vacuum. Your Honor issued an order that said that the government...
Sorry, did I, just to be clear, have I heard anything about any interview on Friday, March 3rd?
Yes. Did you hear about an interview on, who is it? It's Thursday the 2nd.
I know that, but you just told me March 3 is the one you want to focus on. Was there any
Actually, March,
interview on March 3?
it was March 2nd. It was a response to a subpoena on March 1st, and that's the one I should have focused on.
Well, no, it was a subpoena. Was it not served in February, somewhere around February 17?
February 7th,
With-
February 13th.
13th, with the date for appearance to be March 1.
To be March 1.
Yeah.
Witness overslept, so we can use this one. Called in, said come back on March 2nd.
Well, it wasn't come back because he didn't come.
Come on March 2nd.
Yeah.
The point here is this does not come out of a vacuum. Your Honor issued an order that compelled the state to list out 48 hours in advance the witnesses it intended to call. As Exhibit A, we provided the court with the list of witnesses for March 1st, March 2nd, March 3rd. Mr. McMasters is not on that list. From that, we suggest that the court can infer that the Commonwealth had no intent to call him on March 1st or March 3rd, the subpoena on March 3rd, but rather what is reasonable for the court to infer was that the primary purpose of having him come in was to compel him to come in and submit to an interview, which is improper. The doctrine is clear on that, Your Honor. interview itself is additional evidence of the intent in bringing him in. He interviewed with both detectives, Cummings and McIsaac, and we spent a little time already on the various instances in which the interview, first of all, the optics of it, Your Honor. The interview occurred on the 6th floor in the grand jury area where the 6th floor is. This sort of thing is what both federal courts and local courts have expressly prohibited, bringing people into something where there's no evidentiary hearing. And the grand jury is closed, so it's either...
Well, is it the grand jury or is it the DA's office?
Either or.
Okay.
It's improper.
Well,
there's no grand jury.
Yeah.
Or the DA's office, it's improper. Either is for an investigatory purpose.
Yeah.
And contrary to
Got
Rule
it.
17.
But you're suggesting they brought him in before the grand jury or the grand jury space?
Grand jury space.
Well-
where there was no grand jury sitting. Because the case is now...
The bulk of the 6th floor belongs to the district attorney and their offices.
And that would
Now,
be...
but let's just see, Mr. Lee, was he taken into the grand jury or into the DA's interview space?
When you say literally into the grand jury, he was not taken into the grand jury. He was interviewed in an office on the 6th floor, not in the grand jury, not before the 23 members of the grand jury.
Counsel?
Yeah, of course we know that. The attempts, whether it's in their office or in grand jury space, the point is that you cannot use a subpoena for investigatory purposes. And when you look at the actual testimony itself, it's replete with what we characterize as impermissibly suggestive questions. Question, all right, this is Detective, Detective McIsaac. Question, all right, do you remember it being me, or do you remember speaking to another detective? Yes. Question, it was actually me. Answer, yes. Or question, all right, because the night you didn't mention anything about the SUV and the girl hanging out. Answer, I'm pretty 100% sure I stated that there was. Then it's an indication that that Mr. McCaster was cut off. Question, I'm talking about a couple of hours after all this happened. Answer, it was like an hour. Question, yeah, but you never mentioned anything about a woman hanging out of the SUV. Answer, I'm pretty 100% positive of this. I stated there was a girl. Honestly, the Boston PD was kind of treating me like dreadful. Here's an indication that the detectives, who also are witnesses in this case, were attempting to influence the recollection of another witness in this case, and they did it pursuant to the issuance of a subpoena to which there was no intention for this witness to testify. If it were, the witness would have been listed on the email that I received from, or the team here received from the government.
I got it. And as to the final motion?
And as to the spoliation of evidence motion, Your Honor, so we do have evidence that is missing. So the loss or destruction of evidence, this is a case where it's the loss or destruction of evidence. Obviously, the courts account for the fact that when evidence is lost, you cannot say what that evidence is. And there's a long line of cases, both federally and locally, that stand for the proposition that the loss of evidence poses special and unique.
Well, what is the potentially lost evidence?
Potentially lost evidence is all sorts of trace evidence that would have and could have been maintained had that the contents of the hopper been maintained.
Tell me what the trace evidence would be.
Well, you could have very small in the quantity, sort of at the gram level weight of metal that could have been kept. Singed hair, we think, is an important fact that in this case, that the hair singes and there are
Whose hair is singeing?
in our view, it was Mr. Bradley, the person who shot the two victims. When the
His
shooting
hair
gun,
was singed?
it very well could have been, given the description of the shooter. This is the sort of evidence. So we can't say definitively what was there because we don't know. But the law says that...
The law says you have to make some preliminary showing and not merely fancifully invent lost evidence.
Right. And
There has to be some factual predicate to support the belief that there could have or likely was evidence. That evidence is since lost or destroyed, and in this case, not disclosed to your prejudice or detriment.
Exactly.
So-
And this is what
Yeah.
I'm getting at.
And I-
small pieces of metal
Yeah.
from the discharge of the bullet, singed hair that reacts from firing a gun that is close. Very small pieces of leather from the car seat. Small pieces of metal, potentially from the car itself, given the description of the witnesses. And how that happened. Most importantly, and we've talked about this, at least in the form of cross-examination, Your Honor, is glass and the pattern of how the glass was shattered gives us important information with respect to trajectories and the like.
Well,
The
glass-
third category is trace evidence, and trace evidence would have been
The glass is on the BMW left rear window?
side window. Yes.
Excuse me, left rear door window.
Right.
And you're suggesting that that glass, which is demonstrated, pooled on the ground around the base of the window, would have somehow been on the other side of where this SUV had been?
Some of the glass, we've got, and this is in evidence, I don't know if, even in his statement, he says that he saw glass on the ground as he was driving by. That
Who's he?
The-
McMaster?
McMaster, the street sweeper.
Yeah.
That the machine, very well, it's reasonable that the machine could have disturbed it, picked it up, could have been in the hopper, and could have been part of
Could
the
have
evidence.
been. Okay.
Yes, and that's the only standard we have, Your Honor, because it's gone. So it's not, if the court's position is that we have to establish each and every piece of evidence, potential evidence, then we always lose that case. There's a category of trace evidence. Things happen, and oftentimes they are very small, some even microscopic in these sorts of events. And the category is trace evidence. That's why you have these specialists who come around, and that's why they have sieves. That would have been the proper thing to do, to have a sieve to go through the hopper contents. So there's a whole category of
For trace evidence?
Indeed, for trace evidence. That's how we have to defend this case. So they have a theory about what has happened that we strongly contest, and our ability to contest that is abridged because, in part, some of the potential evidence has been lost. So, under Willie, the court has several factors. It must weigh the culpability of the Commonwealth, the materiality of the evidence, the potential prejudice to the defendant. And our view is that the evidence of the contents of the hopper is material. Material in the sense that the loss of or destruction of evidence standard contemplates. That is, you can make a reasonable inference as to the importance of evidence likely to be present in there. The law doesn't require us to say with any degree of certitude that this piece or that piece is in there, but we can give you the sort of evidence that one might
Yeah.
think we can find there.
But I must say, Mr. Sullivan, it seems to me a stretch to think that a city street sweeper, when dumped, of all the debris from the streets of the city of Boston, could then be adequately sifted in some fashion from which trace metals that discharge from the barrel of a firearm would be reasonably discovered, or likely to be reasonably discovered, or some piece of hair or fiber or fabric could be discovered among that debris. That seems to me a little difficult to comprehend or to apprehend.
Well, it's the reason. Well, the standard is reasonably possible, and it's reasonably possible. At least it strikes me as a fairly low standard because of the inherent problems that loss of destroyed evidence presents. So,
Well, yes, but it presumes, had it not been lost, it could have been recovered.
correct.
And I'm not sure I can see how that sort of very fine trace evidence might be discovered from the hopper of a street sweeper.
But that's
I can see that
sort of evidence.
if there was reason to believe a shell casing, for instance, had been swept up, that is something that you could expect to be able to see.
And we do think that that is a reasonable possibility.
Yeah.
Their theory is that there were, well, they go back and forth, but that there's, that there's 5 shots, I think, today. We intend to put on evidence, if we choose to put on a case, that there may have been another shot based on what our experts say. And that's precisely where we may have found trace evidence because it's coming, going
How?
out the other direction. I mean, that could have been, it's reasonably possible.
The other direction is the other way.
That it could have been swept up that could have been swept. No, I think it would have come in the way of the street sweeper and could have been swept up.
How?
In that, well, I'm not putting on my case now, Your Honor, but,
No, you just told me that there is a 6th shot.
that there may be a 6th shot.
Yep.
There may be a 7th shot.
Yeah. Now.
It really depends.
But a 6th shot would have gone through the BMW or past it and somewhere down the Mass Pike, I suppose. It would not have turned around and gone on the other side of the street where the sweeper was.
But not the shell casing, Your Honor. It would not necessarily have gone in the path that Your Honor contemplates. And it very well, it's reasonably possible that it could have been in the path of the street sweeper. So, this sort of evidence, Your Honor, maybe it seems to characterize it, or maybe thinking of it as a more of a needle in a haystack. But it's precisely these sorts of needles that can make the difference between someone unjustly convicted.
Absolutely. Don't tell me the clear law, Mr. Sullivan. I'm asking you about the factual predicate to support the legal claim. And you've told me that it could be trace evidence and might be a 6th shot demonstrated through a shell casing. So I've got that.
Possibility that all these things
Were lost.
were lost and may have been discovered if that area were properly treated. And by the area, I'm referring to the area on frontage where the hopper was done. And that the low standard of reasonable possibility, not even probability, is what the law maintains, and that low standard is frankly met here. The government has an obligation to preserve that and for us to look at it. Otherwise, Your Honor, we would have to accept the Commonwealth's theory about everything. And that's not our job. Our job is to do an independent investigation. Our job is to look through the hopper. Our job, as the court saw just a day or two ago, was to read every manual that, just to be able to say, well, that's not true. Look at this one page in the 10,000 pages of discovery. So by way of analogy, this little piece of trace evidence may be the one page in the 10,000 pages of discovery. And all we have to show is that there is a reasonable possibility that some evidence could have been included in there. And if we satisfy that low showing, the spoliation standard is...
It is not quite as low as you're making it out to be.
Well,
It isn't. We've already addressed this in one of your earlier motions. I've written a decision citing the appropriate standard and the case law as it applies. And it is not a mere possibility. It is a reasonable, I think probability is the term the appellate court uses.
But yes,
All right.
the law does figure a reasonability standard
Yeah.
in there. And our view is that it is reasonable that a street sweeper that moves around and collects evidence, and as Your Honor pointed out, the street sweeper was, along with the taxi driver and the officer, was one of the first people on the scene. And to the extent evidence was moved around or sucked up before the scene was fully secured, that is the prime time, the prime opportunity where this could have happened. And
Well, I find that it does.
It's not reasonable.
Yeah, okay.
That it's not that's not the very sort of space where evidence could be disturbed.
Got it. Okay. Commonwealth, do you want to be heard?
No, Your Honor, other than the fact that we did receive these motions this morning, to the extent that we feel we need to brief the legal issues, which I think are fairly straightforward, I just ask the Court's indulgence to do that when we've had an opportunity to look at that. As far as the factual distinctions are concerned, I think the Court hit on the very things that I would have brought up with respect to the factual issues that were brought out that form the predicate for the legal arguments around it.
Counsel, I'm going to take the three motions under advisement, but I am not going to delay the presentation of the trial evidence pending a ruling on these motions. We will resume the testimony tomorrow morning at 9 a.m. Defense has full leave to question witnesses about the issues that have arisen here today. And to the extent Mr. Baez or Mr. Sullivan or Mr. Leontier, whoever is now focused on the issue, to the extent you want to call any witness back relating to interactions with Mr. McMaster, you have leave to do so. And I would order the Commonwealth to make that witness available with reasonable notice. All right, we will suspend now until tomorrow morning at 9 a.m. Anything further?